in the best way the executive knows how. In this case, the executive chose to send the concerned officers on compulsory leave for 30 days with full remuneration. The defense has relied on the decision of this court in Ezra Chiloba versus Wafula Wanyonyi Chebukati and 7 others, where Adido J held that, quote, our constitution has made fundamental inroads to the common law position, but there is no indication as to whether compulsory leave would amount to disciplinary action. The only prejudice or injustice, if it amounts to it at this juncture, is that the applicant will not be reporting to work, but as regards remuneration, that is a tangible. There was some error there from the court, which can be exactly computed. The defense has shown willingness to compromise the timelines for compliance with the impunity circular, provided that it is done within limits of reasonableness. Indeed, the Solicitor General of the Republic of Kenya drew the present application on behalf of the Attorney General, attended court, and made the said undertaking on behalf of the government. I find that undertaking genuine and a gesture of good faith, considering the fact that the ex parte order was mainly to protect concerned employees from victimization through disciplinary action for failing to provide the required information within the short duration given by the impunity circular. I agree with Judge Radido in Ezra Chiloba case that a mere compulsory leave does not amount to disciplinary action unless the employee is denied his rightful remuneration as a result of the said absence from work. The employer has every right to ask employees to stay away while the employer verifies some matters about the conduct and performance of duty by the concerned employee. However, the employees must expressly be notified of the reason why he is required to stay away and for how long. These are basic tenets of fairness, and they are necessary because the rights of employees at workplace have a bearing on human dignity, and they cannot be swept under the carpet in a democratic society which upholds international labor standards. In conclusion, therefore, consideration of all the matters analyzed herein above, I'm inclined to allow the notice of motion dated 8th June 2018 by recalling the ex parte order granted on 6th June 2018, subject to the following terms. 1. Order number 2, which suspended the circular number OP/CAB.39/1A of 4th June 2018, issued by the first respondent, is hereby set aside. 2. Order number 3, which prohibited the implementation of the said circular, is varied only to prohibit implementation of the default clause, the default clause against the concerned employees who, for just cause, will not be able to present the required information within 10 days from the date hereof, that is to say, by 22nd June 2018. Course shall be in the course. I'll make some slight typo corrections. Thank you so much. Now, we had indicated that I'll be away for a while, and I wanted to, of course, believe I can give direction and the matter be mentioned before the.
That is perfectly possible. It can be placed before the duty date. before 26th. Because Monday I'm in the Court of Appeal, but I will suggest 26th, my office.
Yeah, as the court has indicated, it has set aside the orders that were granted ex parte, stopping the process of the fresh vetting of public officers. This is the right decision, and we want to assure Kenyans and the public at large that the court has today set aside the orders that had stopped the fresh vetting of public officers, and in doing so, the court has clearly indicated that the orders were made on the basis of non-disclosure of material facts and also on misrepresentation of the law and the facts. We are going as a government now to proceed with this process as authorized by the court, and I want to assure public officers and the public at large that this process is going to be conducted in strict compliance with the Constitution and the law. There is no witch hunt that is going to occur. Everybody is going to be given the opportunity to present the information that is required, and this will be done fairly and with respect to the fundamental rights of all the public officers.
In regard to the 10 days that the judge said, what does it mean? Maybe you clarify that.
The judge has clearly indicated that the public officers will be given additional 10 days from today until the 22nd to provide the information that was contained or that was supposed to be provided as per the circular issued by the government.